Am I live, guys?
Yes, sir.
Okay. We're here on a motion for new trial. Let's go ahead and hear argument.
Thank you, Your Honor. Mitchell Mills here for defendant Juan Devora. This is defendant's motion for new trial from a default judgment that was taken. The order of default was signed back on August 13th, 2020. Defendant filed his motion for new trial on the basis that service of process was legally flawed. In the return of service, it shows that Mr. Devora was served at 4308 Chet, C-H-E-T-N-U-T Drive. The certificate of last known address filed by the plaintiffs shows that Mr. Devora's correct address to be 4308 Chestnut, C-H-E-S-T-N-U-T Drive. And Texas law is clear that there cannot be a default judgment when the face of the record of service is not in strict compliance with the rules. And in fact, there's no instance whatsoever in reported Texas jurisprudence where the failure on the face of the record to affirmatively show strict compliance with service of process where a default judgment has been upheld. And in fact, there's the Texas Supreme Court has stated that it will rigidly enforce rules governing service when a default is rendered. And there's multiple cases cited in our motion for new trial. One of them, a 5th District Court of Appeals, Lyle versus Cunningham. Service, the plaintiff served the registered agent, Christopher Lytle. And the court in that case held that serving Christopher Lytle is not evidence of service to the registered agent, Chris Lytle. Both spelled C-H-R-I-S-T-O-P-H-E-R and Chris, C-H-R-I-S, even where both names are used in corporate documents. And there are many cases. There's another one, a Court of Appeals case out of Houston, where Marquez, where the defendant was served at 2155 North Fairview, one word, and the court held that was legally deficient to affirmatively show service on the defendant at 2155 North Fairview, two words. And Judge, that's precisely what we have here. The return of service shows that defendant was served at Chestnut Drive, and his last known address was Chestnut Drive. And so defendant moves for a new trial on plaintiff's, all issues presented in plaintiff's first amended petition on the basis that service.
Is that your only grounds, or I thought you had alternate grounds as well?
Alternate grounds were for equitable relief. So we think we're pretty clear from the case law that we're entitled to a new trial because of the defective service, but we also included alternative grounds, specifically equitable relief because of COVID-19 and the Supreme Court and Governor Abbott's multiple orders, where the attitude of those orders was undoubtedly to alleviate economic hardship. And so we also moved for a motion for new trial on those equitable grounds.
Response?
Yes, Your Honor. Let me start by saying that I didn't file a response to their motion because one is not needed here. This is a very simple motion for you to deny. Counsel is absolutely 100% right on the cases. He's correct on the law, but what they're asking you to do is to compare apples to oranges. They are pointing out that there is a typographical error in our certificate of last known address, and that making the leap that then somehow affects service of process. That certificate of last known address has absolutely nothing to do with process. That is an exhibit that is attached to our motion for default judgment. How can an exhibit to a motion have anything to do with service of process?
So the address that was listed in the actual service was correct. It's just a certificate of last known address was incorrect.
That's correct, Your Honor. And that certificate doesn't have anything to do with process. That is an attempt by the plaintiff to fulfill our requirements under Texas Rules of Civil Procedure 239A, which is we have to provide that to the clerk so they can then provide notice of the default judgment to the party it's taken against. Reading right out of the rule, the last sentence of 239A says, failure to comply with the provisions of this rule shall not affect the finality of the judgment. We have a defect in our certificate of last known address. That is not a defect in service. That is something else. And the repercussions for that are nil. There is no repercussion for failing to provide a accurate certificate of last known address. In fact, reading right out of O'Connor's, they cite Campbell versus Fincher, which says that if you hadn't sent a certificate of last known address at all, it doesn't affect and it's not reversible error. So counsel's correct. They're just trying to shoehorn in a certificate of last known address as some sort of defect in process. That's not what we have here. They have failed to provide any evidence of defect in process to the court. They've not presented any evidence of that. Motion for default or motion for new trial on those grounds should be overturned. As for their equitable relief, the only thing I heard counsel say was there's COVID-19. Well, okay, but how does that get us to the fact that I couldn't, get an answer on file on time? I didn't get an answer on file on time. I didn't do any of the things that I need to do. I'm not hearing that. And simply saying that there's a pandemic going on, I don't think stops the defendant from what they're required to do. Lawsuits haven't stopped being filed. We're all at work today. There's any number of reasons they could have done it. The short of it is, Your Honor, counsel has presented no evidence to support that there's any defect in the service of process. And if they haven't done that—
Is this a car wreck case?
It is, Your Honor.
And Mr. Mills, are you the insurance company? You were hired by the insurance company?
Correct, Your Honor.
It's an issue, Your Honor, within a car wreck case, just for point of clarity, that is dealing solely with property damage to the vehicle. That's how the default was able to be rendered, because we could present the damages that way.
Or just property damage?
Well, just property damage as it relates to this defendant.
Mr. Mills, it doesn't seem like you could be able, I kind of agree. Any of those cases say you can shoehorn a defect in the certificate of last known address. It just doesn't sound right, but I haven't looked at the cases.
And Judge, what I would say is, I mean, if you look at the cases, the whole purpose is that a default cannot be taken when there's a defect on the face of service. In their plaintiff's first amended petition, according to plaintiff's pleading, defendant lives at 4308 Chestnut Drive. In the service of process, the return of service shows Chestnut Drive. In these cases, it's all, there's another one, and I don't have another case, and I don't have it directly in front of me, but the address was very similar. It's Bessie, spelled with an E, versus Bassey with an A. And the court in that case said, no, that's
is the returning correct, or just the certificate of last known address?
The certificate of last known address.
I don't know, Judge.
He says both. I mean, someone go ahead and share screen the return, because that's, I think, going to be dispositive here.
I've got it right here.
Somebody have it.
Let me go ahead and enable it.
Yeah, I can do it. Judge, this is Justin Steinbach. I'm the attorney for defendant Liberty County Mutual Insurance Company in this case. I'm not really affected one way or the other by this hearing, but I'm attending it and I've got it up.
Okay, good. Did you share screen it?
I will right now. Let me see. Are you able to see it?
Yeah, let me see.
It does appear to be CHETNUT.
That's hard to read. I think you're right.
Let me see if I can make it bigger.
I mean, I can see it. It's hard to read.
Yeah. I don't believe there's an S in there.
I don't see an S. What does the case law say about if there's an error in the return? I think that's kind of what's the key thing, right?
Correct,
Yes.
Judge. I mean, it shows that he was served at Chetnut, and everything else that we have indicates that that is not his correct address. That's in plaintiff's pleadings. It's Chestnut, and in the certificate of last known address. And that's why strict compliance is required for a default judgment.
Response?
They're wrong, Your Honor, on that completely. But I tell you what, I will withdraw my objection and agree to the motion, because what we should be doing is looking at the citation. The citation is what will control the citation, and the return and the officer's return is what controls, not the pleadings, not the certificate of last known address. Mr. Mills, excuse me, is just wrong on what it is. The cases are clear. Marquez, Little, Royal, all they've cited. You have to compare the citation to the officer's return on as to
the officer's return isn't correct. It says
yeah.
Chetnut.
And I apologize. I just pulled up the citation. I thought the officer's return was correct, and the certificate of last known address was incorrect. That's not correct. The citation lists Chestnut. The officer's return is where the error is. I didn't realize that until I just pulled up the citation. So the motion should be granted.
All right, I'm going to go ahead and grant the motion. Let's see, did you guys submit an order here? Let me see.
I don't believe so, Your Honor.
Yeah, I don't think you did. So go ahead and send us one. Go ahead and e-file it, as well as email my court coordinator. If you could do it quickly, I can sign it today. Otherwise, I can sign it on Monday.
We will get that to you this morning.
Okay, great. Thank you, guys.
Thank you, Your Honor.
Thank you, Judge.
Thanks, Judge.
Oh, do we already have a trial date? Wait, do we have a trial date on this?
We do.
What is the trial date? Yeah, we do. It's 3/2. Yeah, we do have one.
Yes,
Okay.
sir.
Yeah, never mind.
Thank you, Your Honor.
All right. You guys be safe.
Thanks, Judge.
Thank you. I'm going to take this stuff a little bit out of order. Is everyone here? Oh, wait a minute. It's 10:15. Are both sides here on the Grimp case? Okay. Let's go ahead and take Cedric versus Builder here. We have another motion for another hearing on this. All right. Are both sides here on this?
I'm here, Your Honor, for the plaintiff, Ethan Harriman.
Yes, Your Honor. Stanislav Builder, defendant, pro se.
Okay, let's go on the record on cause number DC 196203, Dennis Zedrick versus Stanislav Builder. Counsel, make your appearances and parties.
Ethan Harriman on behalf of the plaintiff, Dennis Zedrick.
Stanislav Builder, defendant, pro se.
Let's proceed.
Your Honor, I
Each
believe
side
there's
is-
three motions.
What'd you say?
There's 3 motions, I believe, set. We have an MSJ set, and the defendant has one set, and there's a motion for sanctions as well. So which one would you like to hear first?
I'm going to give each side 5 minutes aside to make their presentation on all 3 motions.
Very good.
And Ms. Nandrasi, if you can go ahead and keep time. You ready, Ms. Nandrasi? Are you there? Ashley? Okay, I couldn't see you. I'm sorry. Okay, you have 5 minutes. You may proceed.
I guess I'll go ahead. Your Honor, we filed a no evidence motion for summary judgment on September 25th as to both of Mr. Builder's counterclaims. I also motioned to strike Mr. Builder's response, which was filed yesterday at 4 o'clock in the morning. Is not proper. He didn't give us 7 days notice. So I moved to strike that. There's no leave of court sought. So I don't believe there's a response on file. And in the case of a no evidence MSJ, if there's no response, then it should be granted.
This is your presentation for all 3 motions, so go ahead and make
Okay,
it.
no problem. As for Mr. Builder's summary judgment, he filed an amended motion for summary judgment last Friday and sent hearing notice on the same day, which is not 21 days notice. The Court of Appeals in Dallas is clear that an amended MSJ supplants and supersedes the previous motion, which can no longer be considered. So I'm objecting for lack of proper notice on that MSJ. And in the alternative, I'm also objecting on the fact that it's based on an unpled affirmative defense. Mr. Builder's MSJ is based on the affirmative defense of consent, which is not mentioned once in his live pleading on file, which is defendant's first amended answer and counterclaim. So I object on those grounds as well. And as for the motion for sanctions, Your Honor, it was the same grounds were considered at the last hearing. You chose not to grant those. And defendant here simply hasn't met his burden. He has not shown that they're groundless under Rule 13, which is a very narrow definition that has to be shown that there's no basis in law or fact, and that there's no good faith argument for extension of the law. And further, he's not provided any evidence whatsoever that this is filed in bad faith and for the sole purpose of harassment. So the burden isn't there, hasn't been met. I believe that should be denied.
Okay, Mr. Builder, you have 5 minutes, and let me just ask, so when did you file your response to the plaintiff's motion for summary judgment?
I'm sorry, I feel horrible, sorry. I indeed filed my response to motion to summary judgment late. I felt horrible for the past week, and I tried to confer with the opposing counsel to reset the hearing. They did not agree. So here I am anyway. So Mr. Rama is right. Mr. Rama is also right that I have changed one word in my motion for summary judgment. I've changed argument to the affirmative defense. Mr. Rama is right. This is a very important procedural feature. The motion cannot be granted if I'm not adding that. And I've filed that last Friday. To my defense, I tried to reset those motions for later, but I couldn't because our jury trial is supposed to be on October the 20th. And according to you, it's not going to happen. And I cannot reset anything past October the 20th, past the jury trial date. So Ms. Rhonda Pinson has suggested me to show up at the hearing today and ask for your opinion on that. As for my motions, the motion for sanctions is pretty much the same. It revolves around the fact that Mr. Rama has not, and his client have not presented any evidence whatsoever that I have violated any restraining order, simply because there was no restraining order. They presented no written order, no court transcripts about showing that the judge has ordered anything from the bench, and even setting aside the enforceability of the orders from the bench. I think the order has to be inviting, but they have presented nothing but the testimony of the plaintiff that he is aware that the judge has ordered that. That's simply not true. Nothing like that has ever been. So they have filed this motion knowing that this is groundless, and it was certainly filed for sole purpose of harassment. There's nothing behind that. And as for motion for summary judgment, again, it is very, very simple. We're talking about the consent of an 8-year-old child. My mother was indeed recording the conversations between plaintiff and my ex-wife and my daughter when she was in Ukraine in the custody of her grandmother, my mother. And my mother gave vicarious consent to that recordings. Vicarious consent doctrine is a doctrine sorry, widely adopted by all the courts in Texas and the US right now. Mr. M and his client are suggesting that an 8-year-old child should have consented to be recorded. And that recording was in the best interest of the child, because even though the child tells that she's getting all the prescribed medicine she has, my ex-wife is trying to accuse me of taking her off the medicine, which may potentially increase the amount of medication given and harm my daughter. So it was in the best interest of the child. Not to mention, Mr. Zidrick is usually bad-mouthing me on the phone, which is also damaging to the child. So please suggest how shall we proceed on that.
All right, so
Please
this is what we're going to do. The court is going to go ahead and grant the plaintiff's motion for summary judgment, deny the defendant's motion for sanction. We're going to pass the defendant's motion for summary judgment, and we're going to go ahead and reset the trial setting. So you can reset your summary judgment at some point. I'm thinking of resetting this to maybe May of next year. What after the plaintiff's motion for summary judgment, what's still going to be left in this case?
Just the wiretapping claim, Your Honor.
The one I have summary judgment for, yes.
Have I already granted summary judgment on that?
On
No, Your Honor,
wiretapping, no, this is a motion I've brought in. So if we can hear it today, because if we're going to reset it procedurally, it's going to be absolutely the same motion as we have on file. And it is absolutely the same motion, except for this one word that has been set for hearing on September the 24th.
Mr. Zedrin, I'm sorry, Mr. Herrera.
Well, yes, Your Honor. I mean, I object. I mean, regardless of the same grounds, I object because it's not pled. He's not pled consent as an affirmative defense, and it can't be considered as a basis for his summary judgment if he hasn't pled it. And furthermore, it's not his defense to assert. If what he says is true, he doesn't have personal knowledge to make the comment that his mother vicariously consented. So there's an evidentiary problem as well.
I'm going to pass a summary judgment at this point. I'm going to reset this case for trial on May 4th. Yeah, May 4th. Okay, anything else, guys?
And
That's it. That's all I have, Your Honor. I have a quick question. Do we still need to show up on Tuesday then for the Zoom?
No, we're just going to reset you to May 4th.
Okay.
Ron, did you get that?
And
all right.
Sorry for that. And I will reset my motion for summary judgment, right?
Yes.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Okay, perfect. All right, let's go to the next hearing. What was that noise? You guys hear that?
Yeah, I have no idea what that was.
Who was it? Mr. Henley, was that you? Was it the bear behind you that made that noise? All righty. So I think our next thing said is the Grimp case, or both Grimp v. Wilson. Are both sides here for that?
Yes, Your Honor.
Yes, Your Honor.
Okay. Do y'all want a record for this? We're on YouTube already, but we can do a record as well as if you like.
YouTube's fine.
What?
YouTube's fine with me, Judge.
Okay. Ms. Holcomb, is that okay with you, or do you want a court
I would
record?
prefer a record, Your Honor.
Okay, let's go on the record on cause number DC 189386, Grimp v. Karen Wilson. Counsel, make your appearance.
Michael Myers on behalf of plaintiff Mary Grimp.
Rhonda Holcomb with the Lacrone Law Firm on behalf of defendants Eric Morris and Carolyn Milledge.
All right, let's proceed.
Your Honor, how would you like to, we have a set of notice on our motion for continuance of the hearing. I can give you a brief background. I'm probably one of the stranger car accident cases I've ever been involved in.
Okay.
My client was rear-ended by a pickup truck driven by a female. And that's pretty much where, well, except for the fact that Mr. Morris, Eric Morris, who's one of the defendants, owns said pickup truck. And that's about where I think the stipulated facts would end. A lady, either probably Karen Wilson, or could have been Sylvia Valdez, or it could have been now maybe Carolyn Milledge, exited the vehicle and gave my client some information at the scene of the accident. Now, my client obviously took a picture of the vehicle that struck her. So that's how we know it's the vehicle in question, right? She got a copy of the license plate, and that's how we know Mr. Morris owns the pickup that struck her. The lady who exited the vehicle, I don't know who she is for certain, because she either gave a real name or a fake name or two fake names. So she exited the vehicle and she gave the name of Karen Wilson, which is a defendant, and then identified the passenger as Sylvia Valdez, who's also a defendant, but she hasn't answered. Then she gave an address for Miss Karen Wilson, which turned out not to be a correct address for Karen Wilson. I don't know if it was Sylvia Valdez who was given this information to my client and then saying it was her on the passenger side or anything like that. The other information that my client wrote down that this lady who exited the vehicle gave her was a insurance policy number. Now, we have subsequently found out that insurance policy was expired at the time, and we had to go chase down the insurance company and then get them to release records and so on and so forth, and found out that the expired insurance policy was issued to a Carolyn Milledge, M-I-L-L-A-G-E, who's now been added as a defendant in this case just recently, because we have that information. Okay, so that's kind of the background. The only thing I'm sure of is the pickup that struck my client's vehicle was owned by Eric Morris. Who the driver was, I really don't know yet. So earlier in this case, Mr. Morris filed a no evidence summary judgment motion, the same one we're set here for today. And we had a hearing, and Judge, I think one of your comments was, in order to have this negligent entrustment issue resolved, you're going to have to have the deposition of Eric Morris. All the parties agreed, and I think Ms. Holcomb is new to the case because I was the other attorney from her office, I guess is no longer there. His name is Michael Kelly. Very agreeable person. We decided to set the deposition of Eric Morris, and it was set end of March of this year. And then, of course, we all know what happened in March. So COVID takes off. I don't know. At the time, I'm not sure I know anything about COVID, really. So much information about it. But at that time, no one knew really how it's transmitted. We decided, for the sake of all the parties involved, let's just cancel the deposition. And in April, they had reset their no evidence summary judgment motion because we thought we'll have the deposition and I'll be able to respond. And they said it in April. And I think out of the same caution, Mr. Kelly decided I'm going to pull our motion too. So yes, some time has gone by. All I need is the deposition of Eric Morris. I'd like to have the deposition of Eric Morris. I've noticed.
So since April, you haven't taken the deposition of Eric Morris?
Correct. That's true, Judge.
Why not?
We didn't get together on the case. I didn't ask for the dates until later, and so that's my fault. But
have you noticed it?
Excuse me?
Have you noticed it?
Just recently, yes, Judge.
And did they quash it, or what happened?
I expect that they'll quash it either today or Monday. I asked for dates, and they said since the hearing's set, we're not interested in giving you dates. And so I just said, well, okay, I'll just notice it. So that's what I've done. And second, just kind of I guess a procedural issue or a legal issue. We've asserted other claims against Mr. Morris. So the other claims is if he's sticking to this position, which I understand he's taking, is that he didn't even know his truck was gone. So presumably he didn't know who had it. If that's the position he takes when we do his deposition, I think my negligent entrustment claim probably goes away anyway, because if he didn't know who had it, I can't really say that he negligently entrusted it to a person that he knew was a bad driver, so on and so forth. That being said, I still need his deposition, because if he's going to stick to that position, my position is going to be, you didn't secure your vehicle, and apparently you let anybody drive it, and that's negligent. Our basis of another negligent cause of action against Mr. Morris. So what I suspect is, I mean, unless he changes his tune, my negligent entrustment claim.
So if I understand this, Mr. Myers, we previously set this for summary judgment. I gave you kind of a chance to take Mr. Morris's deposition, kind of gave you a break because you could have taken it before. And then over the last 7 months, you never took his deposition. I mean, it makes me as a judge look a little silly, doesn't it, that I kind of gave you a break to give you a chance to take this deposition to be fair. And then you haven't taken the initiative to take this step. I mean, am I understanding this correctly? Is that what happened?
Well, other than I think any silliness belongs to me and not you, Judge.
Well, I mean, I'm the one who went out on a limb to give you the opportunity to do this. I mean, did the defendants want me to do this, or did I do this because you requested it?
I think, well, I don't think the defendants wanted it. And in fact, we did have it set. The deposition was set to go forward in March.
But you never followed up.
After the March, that's correct. After the March setting of the deposition, that's correct.
Okay. Ms. Holcomb?
Yes, Your Honor. Not to beat a dead horse, but it isn't Mr. Myers' duty to his client to prosecute timely and diligently. And in the best interest of my client, when he contacted me on, I believe, Thursday of last week, and after getting a reins of this case, we felt it was in the best interest to proceed with this hearing because we had twice agreed to remove the hearing for the sake of the depot, even after you had graciously allowed him more time back in November of 2019. You know, Mr. Myers never reached out to us to try to get a Zoom deposition, which we would have been more than agreeable to. We do them. Now we're doing them multiple times a week because we can. And we would have liked to get this over for our client as well. And now he's pulled in Miss Millage, which is another issue that I won't take the court's time on today because it's not set for hearing today. Quite frankly, Your Honor, I understand if you feel the need to, again, allow him more time and abate hearing the no evidence MSJ. At this point, other than Mr. Myers not giving a proper reason for not diligently attempting to get the deposition. It's only suspicion and supposition that he's provided in terms of my client and any claims of negligent entrustment. He didn't serve discovery until February of this year. And discovery responses.
So let me ask you a little bit about the procedural position of the case right now.
Yes, Your Honor.
So which defendants have actually filed an answer at this point?
So my clients, Eric Morris and Carolyn Millage, we have entered answers or filed answers on their behalf. Miss Karen Wilson is represented by another attorney.
Miss Ellis over here?
Ellis, yes.
That is me. Good morning, everyone.
And it's my understanding that Miss Sylvia Valdez has not made an appearance in this matter. And just to very briefly to attend to the procedural matter, we do have an MSJ based on statute of limitations from Ms. Carolyn Millage, and that has not yet been set.
You know, it's tough. I really try to give people an opportunity to try their cases on the merits. I mean, I get attorneys sometimes frustrated with me that I'm not more strict on the rules, and that I don't, you know, when I did kind of what y'all do in private practice, I did a lot of car wreck cases, and I understand the difficulty with it, and sometimes, you know, things you know, drop through the cracks, and, you know, I always encourage people to work together. But when you're given a break by the judge to do something, I mean, this could have been done before the summary judgment, and then you wait, and then there were 2 additional extensions. Is that right? Am I understanding that, Ms. Holcomb?
There was a hearing set in March for the MSJ after your November 2019 when you allowed him more time, and we agreed to pull that down and scheduled the deposition to occur March 30th. And then that didn't occur, of course, and so we again pulled down the April MSJ hearing. And so we've waited since then.
So I originally last November
Yes.
gave him a chance.
Yes.
And then in March, he still hadn't taken the deposition. And then
Correct.
in April, he still hadn't.
Correct. Yes, because when discovery requests were sent in February, it was made known to him, hey, these requests are going to be due after the date of the current MSJ hearing, which was the second setting. So it was pulled down by agreement. The deposition was set for March 30th. That didn't go forward. You know, we had reset the hearing for April to occur right after the deposition testimony, but again, it was pulled down. But you're right in the short version is there's been no attempt to reschedule the deposition for March 30th to October 8th when Mr. Myers contacted me.
Can I add some clarification?
That I'm aware of.
We had the MSJ hearing that we appeared before you happened in November. That was number 1. Then they reset it for April because we agreed to the deposition dates in March. And in March, of course, COVID hit. And then in March or April, they pulled their setting because of COVID / we didn't do the deposition. I don't know how discovery that's issued in February is due before a hearing in April. I mean, due after a hearing in April. But anyway, there's 2 settings, November and April, and then this one. So the first one, the court was gracious on that one. The second one was pulled down, presumably because of concern for the parties and the COVID, and I hadn't gotten my deposition because we decided to call it off because of COVID, and nobody really understands COVID. So there was one in between the November and now. It wasn't there. There hasn't been 2 settings of this hearing in between.
So it's been over 11 months since I originally gave you the opportunity to take Mr. Morris's deposition, and the first time you noticed it was last Thursday.
No, it was noticed.
It was noticed, I guess, and it was
For the end of March.
End of March, and but since between March and August, or March and October, you never made any efforts to try to take the deposition.
Not that I don't think that, not that the court is going to think overly timely. I did reach out to Michael Kelly, but I got a response from a secretary saying that he had left the firm. So then and they eventually directed me to Ms. Holcomb. So, but that was maybe three weeks ago or 4.
No, it was Thursday. It was October 8th that I talked
That's
to
when
you.
I talked to you.
Yes. And I'm not aware of any attempt to reach me prior to that date.
I'd never dealt with Ms. Holcomb on this case.
Mr. Myers, you just have to understand from my standpoint, I feel like you've made yourself obviously not look great, but also made me not look great because I trusted you that you would follow up and take the opportunity to do this deposition and diligently prosecute your case. And 11 months later, you never did. It puts me in a difficult position because a lot of times defense attorneys it's usually defense attorneys, sometimes plaintiff's attorneys are upset with me and they say, Judge, you should strictly enforce these rules. And then attorneys will say, look, Judge, give me one more chance. I'll give you so I'm kind of going out on a limb for you when I do that. And now you put me in a situation where 11 months have gone by. You haven't taken the deposition. It's not fair. It makes you look bad. It makes me look bad. It makes the whole system look bad. I don't understand why you've done this way. And so I hate to do it because it's not fair to your client that this has happened, but I'm going to go ahead and grant the summary judgment. Or I guess I'm not necessarily, I guess I do have to. Did you file a response or just a continuance motion?
Yeah, the response was filed.
Okay. All right, so I'm going to deny the motion for continuance.
Okay. Thank you, Judge.
All right, let's go forward with your motion.
Yes, Your Honor. And again, to make this as efficient as possible for the court's time, as of today's date, the claims against Mr. Eric Morris are negligent entrustment, that he negligently entrusted his vehicle to Sylvia Valdez, who he knew or should have known was a reckless or incompetent driver. There's been no evidence presented that Miss Sylvia Valdez was reckless or incompetent, or that she was on the date of the accident. There's no evidence that my client knew her. There's no evidence that he entrusted the vehicle to her. And so quite frankly, the elements of negligent entrustment are not met. There's no evidence that supports this claim. And so that is the basis of our no evidence MSJ as to Mr. Eric Morris and the negligent entrustment claim that's been filed against him.
Response.
Your Honor, we know that Mr. Morris owned the pickup truck. We know that he entrusted it to one of 3 people, and the element is he entrusted it to an unlicensed or incompetent reckless driver. He entrusted the vehicle to another person. He wasn't driving it, so we know it wasn't him. We know the truck was in somebody else's possession, and we know that the person was a reckless driver because she ran into the back of my client's vehicle. And I think that proves the negligence portion of the elements as well, as far as the driver was negligent on the occasion in question. She rear-ended my client, and the driver's negligence approximately caused my client's injury. And it's all, we have affidavit from my client plus a picture taken at the scene and the 2 people that were identified in my client's handwritten notes that she took at the time of the accident.
So what day did you file a response to the summary judgment? I don't see a response that was filed.
November 15th, 2019.
Oh, November 15th, 2019. Okay.
And if I may, Your Honor.
Yes.
I have reviewed the deposition testimony of the plaintiff, Ms. Grimp. And from what I read, she did not say she wrote the information down. She said the information was written down by the driver and or the passenger of the vehicle that impacted her. She did not see these persons or person writing it down. They handed it to her. So that's one correction. Secondly, Mr. Myers has asserted my client is negligent, but we've not had trial on this matter, so that has not been proven, and that is not the standard for negligent entrustment. There's no evidence that Sylvia Valdez was negligent, reckless, or incompetent. Further, and not to beat a dead horse, but Mr. Myers has had the opportunity to get all of the information he possibly could have gotten from my client outside of his discovery responses, which indicated that he did not entrust the vehicle to Ms. Valdez. He did not know her. He did not entrust the vehicle to the other defendant, Ms. Wilson, nor did he know her. And if there was any kind of mystery to determine, that should have already been done. And at this point, it hasn't been. So there's no evidence that he, in fact, entrusted the vehicle to her.
Okay. All right, so I'm going to go ahead and grant the summary judgment. I will say this, that this isn't obviously an interlocutory summary judgment. So Mr. Myers, if you decide you want to file a motion to reconsider, you'll have time to do that. I would still urge you to, take the deposition of Miss Morris, and then has Miss Millage or whatever her name is.
If we may, yeah, can we address that? Because it's not Miss Morris, it's Carolyn Millage, who is Eric Morris's wife, but he is asking for her deposition as well. And Your Honor, because he filed suit against her I believe it was about a year and a half after the statute, I advised him that I wouldn't agree to provide dates until this court heard that statute of limitations MSJ.
I'm not making any comment on that.
Right.
What my goal is here, to be honest, just to be a little bit transparent, is I have to admit I feel kind of, at the time Mr. Myers was with the firm of Rogge Dunn, a very well respected firm. I don't know your new firm. I gave him the benefit of the doubt that he would take this deposition, and he didn't. And so, in a backhanded way, I'm trying to give him one more chance to allow him to do this. I mean, this appears like this could be malpractice if we miss the statute of limitations. And so I want to give him one last chance to try to take this deposition, but I can't force him to do that. And so I'm inclined to, go ahead and file your motion, go ahead and set it. But I would be inclined, if he actively pursues this, to go ahead and let him do that discovery. And it's not a ruling. I'm just trying to get Mr. Myers to kind of do what he needs to do. And I thought that a year ago, when I allowed him to do this, that it would have been done. I've never had any issues with Mr. Dunn, Rogge Dunn's firm. They're excellent lawyers. They've always been very kind of on the ball, and something like this happening is kind of surprising. But I know you're not with Mr. Dunn's firm anymore, so I don't know kind of what exactly is happening here, why. But I'm trying to give you, one last chance to fix this. So, but kind of put the the incentive on Mr. Myers, kind of put the burden on Mr. Myers to do this. So if he doesn't do anything, then we can go ahead and clear out this case and dismiss it. But if he does take action to try to get this discovery done, then I would allow him to do that. And so, does that make sense?
Yes, Your Honor, they've already been noticed. The depositions have already been noticed.
And we will file a motion to quash because it was unilaterally noticed without conference.
I asked for dates. I don't know. Conference, but.
Who have you noticed? Morris and Millage?
Your Honor.
I'm just going to say, if he actually goes forward with this, I'm going to allow him to take those depositions. Whether or not necessarily on the date that he's noticed them for, but I'd encourage you to work this out if he shows initiative. Now, if it's 6 months from now and he still hasn't taken the deposition and he still hasn't moved to compel and all that kind of stuff, then, we'll address that. But I want to give him an opportunity to do this, but I also want to place the burden on him to actually do this. You know what I mean? He needs to take the initiative. That's why I granted the summary judgment. If he's able to take the deposition and finish discovery on this case and establish, you still have another shot. It's just kind of the burden is on you, Mr. Myers, to get it done. And I'd encourage you, if you want to keep this case alive, and maybe you don't, if you want to keep this case alive, you need to really take the initiative to get this discovery done. So if she quashes it, don't just sit on the sidelines and go, well, she quashed it. There's nothing else I can do. You can move to compel the deposition. You need to do that kind of stuff if you want to keep this case alive at this point.
Will do, Judge. Thank you.
Anything else, guys?
Thank you for your time, Your Honor.
Do you have you submitted an interlocutory order?
I believe we did. I can
go ahead. Why don't you resubmit it as an interlocutory order, because I think you submitted it as a final order.
Yeah.
And email that as well as e-file it with the court coordinator.
Yes, Your Honor.
All right. Anything else, guys? Ms. Ellis, you haven't talked much. Did you want to say anything?
I was just present. I want to note my appearance for the record. I'm Kenya Ellis on behalf of the defendant, Karen Wilson. And I suspect you'll be hearing from me in a similar motion very soon, Your Honor.
Okay. Is he trying to take your client's deposition?
No, sir, Your Honor. There's no evidence to prove that my client had anything to do with it. You haven't heard any mention of Karen Wilson at all throughout this entire proceeding.
Is that the same person as Karen Millage, or anyway, it doesn't matter.
No, it's a different person.
We'll figure this out in the future. Good luck, guys.
Thank you.
Thank you.
Bye-bye. Okay, I believe our next hearing is Angel Sword LLC versus Watson. Anyone here on that case?
Mr. Henley is muted, but it's Mr. Henley and myself.
Okay. And it's the motion to transfer venue.
I'm here too.
Okay, Mr. Henley, you there?
Yes, Judge.
I don't know if you noticed you have a big bear behind you.
I do. And that was not the bear that you heard earlier. I think that was Mr. Builder.
Oh, was it? Okay.
I think it was. I have a dog in this office, and it wasn't her either, and I was on mute.
I'm actually at the courthouse today, so my dog is back at home, so it wasn't him. So I've had a chance to kind of look at everything. I'm ready to rule because this is kind of a continuation. I just needed additional briefing. But if there's anything anybody wanted to say, I'm happy to do that.
Well, we just want to re-urge that they've had this case for more than 2 years down in Hayes County. Everybody down there except Jeremy Levy lives in Hayes County or Travis. I mean, the cops, both with the Austin Police Department and the Travis County or Hayes County Sheriff's Department, the employees of Angel Sword. My client lives in Travis. Their client lives in Hayes. Everything. I mean, this is a small family business dispute and divorce. And there's just, a tangential tie here to Dallas as everything establishes. This, would be wholly inconvenient. And frankly, Ms. Watson cannot afford this process. And as we briefed everything from the Fisher case, it wasn't completely on point, but it certainly had distinguishing factors that indicated that first filed still matters. Even though it was a corporate form and in a different entity in that respect, we're still talking about the same germane parties stemming from a marital dispute where the central asset is everything that is Angel Sword.
Your Honor, if I may respond.
Sure.
The factors that he's discussing about, where things are, et cetera, I believe you heard argument on that at the last hearing. You said that you would have ruled at the last hearing, and obviously you found that there was enough of a factor to keep it in Dallas County just on the facts. And really, this was all supposed to be about this AWE case. And we obviously take two different views of that, but the sides do. In fact, we don't even use the same name in our briefing of the case. But the first thing Mr. Henley told you was they've had this case for 2 years down in Hayes County. We plaintiffs, the corporate entities, haven't had anything down in Hayes County for 2 years. And that is what AWE is all about. These are two separate, legally distinct parties, two corporations suing in Dallas County for something not related to the division of a marital estate, which was the basis of the holding in AWE that sent everything back to your court from Judge Wysocki's court. And that, Your Honor, they lead with their chin. You've got to transfer this case down to Hayes County because there's a divorce case pending there. And AWE tells you that that is not the law. And as we pointed out, AWE is based on a case that says an attorney can't even go back to the family law court to collect his fee. And so we've proved under the tech specialty trailers elements, the case filed not by Daniel Watson, filed not by a party to that Hayes County case, deserves to remain here in Dallas County.
I'm going to go ahead and deny the motion to transfer.
We did.
Did you submit an order on this
today?
What'd you say?
We did submit a proposed order this morning, Your Honor. I also submitted an order granting our motion to strike, but that's probably moot.
Okay. Go ahead and email that to my court coordinator as well, and I'll try to sign it today.
Okay. Thank you, Your Honor. May we be excused?
All right. Thank you, guys. You have a good day.
Thank you, Judge.
Good luck with your bear, Mr. Henley.
I will, Judge.
Good to see you guys.
All right. Take care.
Okay. Our next hearing is Wildwood National Corporation versus Shin-Chan. Is there anyone here on that case?
Yes, good morning, Your Honor. Papul Chaudhary and Ms. Sol Lee on behalf of plaintiffs Wildwood Natural Corporation and Chancho Park. And we also have Mr. J.P. Lee with us. He is a law clerk that just started with us yesterday and just now sat for the Texas Bar.
Oh, congratulations. Good luck.
Thank you, Judge.
And this is Daniel Rowland. Excuse me, Your Honor.
No, I'm sorry. I was asking if the other side was here.
Oh, yes, Your Honor. My name is Daniel Rowland, and I'm on behalf of the defendants, and that is Kipi Na and the Sihana Corporation doing business as Shinshan Oriental Market. And Mr. Whitten, Attorney Whitten, will also be sitting in this as well.
Okay. All right. Did you guys want a record for this?
Yes, please, Your Honor.
Yes, Your Honor.
Let's go on the record on cause number DC 1916287, Wildwood National Corporation and Chancho Park versus Gi Bi Na, also known as KPNA and Kipi Na, and Sahana Corporation, formerly doing business as Shinshan Oriental Market. Counsel, make your appearances.
Good morning, Your Honor. Papul Chaudhary and Sol Lee for plaintiffs Wildwood Natural Corporation and Chancho Park.
Daniel Rowland on behalf of Kipi Na and the Sahana Corporation as defendants.
Let's go ahead and proceed.
Thank you, Your Honor. A couple of preliminary items. One, we'd like to reserve any remaining time from my principal argument for rebuttal, if the court will allow that.
What? I'm not sure what you're saying.
I'm saying any time that I have after my principal argument, I'd like to reserve it for a rebuttal.
Okay.
And
We
also,
only have 15 minutes, Your Honor, so hopefully we can get this all done pretty quickly.
Okay.
and also I've got a few demonstratives. May I use the share screen function?
Sure. Let me enable that. Go ahead.
Thank you, Your Honor. This case was filed on October 7th, 2019. Originally, we had a trial date of July 21st, 2020. So accordingly, at that time, under TRCP 195.2, that rule sets the dates for designation of experts. It says that for experts testifying for parties seeking affirmative relief, they need to be disclosed 90 days before the end of the discovery period. All other experts must be disclosed 60 days before the end of the discovery period. Now, in the first 6 months of the case, the defendants had no counterclaims, and a fact discovery period closed June 21st, 2020. And what that means is that the affirmative relief or expert deadline was originally March 23rd, 2020, and all other experts needed to be disclosed on April 22nd, 2020. Now, no experts were designated on March 23rd, 2020, or April 22nd, 2020. This was the first time that defendants completely blew the expert designation deadlines in this case. Now, on May 27, 2020, the defendants filed a motion for continuance seeking not only a trial date extension, but also an extension of the period to designate experts. This court heard that motion for continuance on July 10th, 2020. And at that hearing, it was agreed that the parties would enter into an agreed scheduling order concerning the disclosure of experts and their reports. Now, the parties entered into that agreed scheduling order, which was the court actually entered itself on July 17th, 2020. And I'd like to go ahead and put that on the screen. Here we're looking at the agreed scheduling order, and you'll see it sets the following deadlines for expert disclosure. August 7th is the date for the party seeking affirmative relief to designate experts and provide reports. August 24th was the deadline for the party opposing affirmative relief to designate experts and provide reports. September 25th was the designation of rebuttal experts and provide report deadline. And finally, October 23rd was the deadline for all expert discovery to close. And again, this was agreed by the parties, entered into the court. On August 7th, the defendants disclosed the expert Wendy Carlson well in advance of the August 24th deadline. But in this disclosure, there was no expert report of Ms. Carlson, nor any opinions. It only stated that they will be provided. Now, August 24th, which was the deadline for the party opposing affirmative relief, to which defendants are the party opposing affirmative relief in this action, that deadline came and went without any expert report of Ms. Carlson served. But not only that, but prior to this, the defendants did not seek any leave for extension of this deadline. They never contacted us, they never contacted the court to say, hey, we can't meet the August 24th deadline for whatever reason, which now they claim are health issues with Ms. Carlson. Nevertheless, even then, weeks passed after this deadline, and they still never said anything. They still never filed a motion with the court. But finally, on September 9th, 2020, we raised the issue with defendants. And you would think once defendants realized their error, they would have immediately moved to seek leave to file their report late. But no, they didn't do that. They mentioned to us Ms. Carlson's health issue, but they never raised it prior to the deadline and only mentioned it after we called them out on September 9th. Now, yes, we did discuss trying to work something out, but frankly, why should we work something out at that point? They never reached out to us prior to the deadline. They blew the deadline. And even then, they never reached out to us. And only when we reached out to them on September 9th did they even try to have this discussion. But even then, they never sought leave from the court for an extension. Finally, we filed this motion on September 18th, 2020. And the defendants still did nothing concerning the expert report. On the 25th of September, we served a disclosure of our rebuttal expert, Susan Abbey. But since there's no expert report to rebut, there is no rebuttal opinion for her to offer. And finally, On October 2nd, 2020, 39 days after the deadline had passed, without seeking any leave of court, the defendants just served their expert report of Wendy Carlson. And on top of that, this week, October 13th, 2020, defendants filed a partial MSJ, which consists of a traditional MSJ and a no evidence MSJ. But the traditional MSJ relies on this expert report of Wendy Carlson that was not timely served and no leave was ever sought to serve it late. This traditional MSJ is especially improper and insidious because defendants have set the hearing for it on November 9th, 2020, meaning our response is due November 2nd, 2020. So even though there's no expert report of Wendy Carlson properly in this case, and even though defendants twice blew an expert deadline, if this traditional MSJ is permitted to stand and be heard on November 9th, our effective deadline to submit a rebuttal report is November 2nd, which is about 2 weeks from now. Even though Wendy Carlson's expert report is not actually in the case. I'm going to actually put up a page from the from the traditional MSJ. It is page 24. And you'll see here, one of their principal arguments, their traditional MSJ is forgery. And I've highlighted here where they're actually citing to Ms. Carlson's opinion, and they've actually attached it here to this MSJ. For the court's convenience, I am going to put up...
Can I see a copy of what the attachment is?
The attachment, you mean...
We did attach that, Your Honor.
They're not disputing it.
No, we don't dispute that whatsoever.
No. Okay. Well, what I'd like is to be able to see the attachment that was noted about Ms. Carlson. There was, I think, a report or an affidavit. You went through that kind of quickly. Can I see what the attachment was?
Yeah, just give me 1 second.
It's also in plaintiff's response, Exhibit A. It should be the same attachment, Your Honor, if they're referring to the report.
Let me take a look at it.
Yeah, so in this, I'm referring to the report, and I just have to scroll down to sort of get
And Your Honor, on the report, it's page 4 and page 5. It's under the examination where it says that it was the highest level of certainty that eliminated our client as being the author of the notes. It is the highest level of certainty an expert can give regarding forensic document examination.
I appreciate that. Can I just look at it, whatever?
Yeah, I'm trying to pull it up, Your Honor. Just give me 1 second. Just have to find the page from there. Yeah, I think this is it.
Am I understanding correctly that he attached a report or an affidavit that he had not attached to his request for disclosures?
No, Your Honor.
No.
We can go through that. I know it's only a 15-minute hearing, and we can actually go through everything. I think that we can dispose of this motion very quickly.
Your Honor, I'm not finished with my argument. I would like to be able to finish that.
Okay.
All right. You have another 60 seconds.
Your Honor, we have rules and deadlines for a reason. Litigating this case through trial does not work properly without rules and deadlines. I'm going to put up here I'm not going to put it up. I don't have time. Here, the defendants blew a TRCP deadline for expert designation, and then they got a second chance with an agreed scheduling order, and they blew that too. And on top of that, regardless of the reason they missed the deadline, they never sought leave for an extension prior to the August 24th deadline. That's what you do when you have a deadline you're going to miss for whatever reason. You ask the court to be relieved of it before you miss the deadline. That's the practice of law 101. And let's just say by accident, you missed the deadline and you don't seek a leave for an extension prior. Well, then what you do is immediately once you realize the deadline was blown, you file a motion and you ask the court for leave. You beg the mercy of the court to give you a reprieve. That's what you do. What you don't do is you don't never seek leave prior to the deadline, blow the deadline, never seek leave after the deadline, even after opposing counsel informs you of the issue a few weeks later. And what you don't do is 39 days after the deadline, serve a report. And then also, you don't, the week of the motion to strike hearing, serve a traditional MSJ that relies on that expert report, knowingly attempting to compress the time for plaintiffs to prepare a rebuttal report to an expert report that's not even properly in the case. All of that's not only improper, Your Honor, it's sanctionable. We have a motion for sanctions against defendant and their counsel that will be heard on October 26th. And this sort of misconduct is a huge example of the rampant misconduct that comes from defendants' counsel on a weekly basis in this litigation. Now, if rules and deadlines, especially agreed deadlines, are not enforced, what's the point of the rule? What's the point of the deadline? A deadline has no meaning if it is not.
Okay. Mr. Rowland.
All right. Thank you, Your Honor. As the court knows, we are here for a specific reason, which is the plaintiff's motion to strike defendant's expert forensic document examiner, Wendy Carlson, for untimeliness. And as you've heard plaintiffs continually say, they say that we blew through deadlines. This is false. As they've said, defendants timely designated Wendy Carlson. That fact alone completely disposes of plaintiff's motion to strike Wendy Carlson for untimeliness. Under the agreed scheduling order, which plaintiffs showed Your Honor, that was entered because plaintiffs refused to give over the actual original ink documents for examination. It was only once the court ordered them that they had to, that we entered this new order that could have an expert. Then, once they had that agreed order, as plaintiffs say, we actually designated Mrs. Carlson 10 days earlier than we were supposed to. And just from that issue, this motion for untimeliness needs to be dismissed just because of that, because we haven't blown through any deadlines. We properly designated our expert 10 days beforehand. When I read plaintiff's motion and I just heard plaintiff's arguments, it's clear that plaintiffs are falsely equating an expert witness with an expert report. And on that note, I would like to turn the court's attention to Texas Rules of Civil Procedure 195. 195 is titled Discovery Regarding Testifying Expert Witnesses. And 195.3 goes into what happens if a report is furnished with the designated expert and what happens when a report isn't furnished with the designated expert. So I'm going to read if no report is furnished. So you can obviously designate an expert and not furnish a report. It's very clear under 195. 195 says, if no report furnished, if a report of the expert's factual observations, tests, supporting data, calculations, photographs, and opinions is not produced when the expert is designated, which we timely designated Mrs. Carlson, then the party must make the expert available for deposition reasonably promptly after the expert is designated. The other side plaintiffs have never asked for her deposition. Oddly enough, when plaintiffs designated their rebuttal expert and also didn't include an extra report, which they admit, which is just right under 195.31 again, we did ask for her deposition, but were rebuffed, and they refused to give the deposition of their plaintiffs, their expert, until after this hearing.
I'm a little confused here. So Mr. Chaudre says that you designated the expert, whatever, 46 days or 36 days late. You're saying it was 10 days early.
Yes, no, that's what I'm saying. They're confusing the report with the expert because, and I'll get into that, we designated our expert promptly on time, even early.
So if I understand it, you designated the report 46 days after the deadline, but you actually designated 10 days before the deadline. Is that?
Yeah, the expert was designated on time. The only thing that was late was the report. But what's clear under the Texas Rules of Civil Procedure is that you don't have to.
I get that.
Can I respond to that?
All right. And so we've talked about how they're falsely equating an expert witness with an extra report and not abiding by Texas Rules of Civil Procedure.
Let me hear from the other side, Mr. Rowland.
Oh, but okay. But I have a lot more, Your Honor, about surprise and prejudice because we reached a Rule 11 agreement about this exact issue. And I would like to talk about that because we did tons of due diligence because of an injury. Our expert had a back injury. That's the only reason they came to the report. And so we have a lot to talk about regarding that before we give any rebuttal, because on the first part, when you're trying to strike an expert, even if this wasn't dispositive that we obviously timely designated her, you know, we have Exhibit A, which shows her expert report. Why they're trying to do this is just because they want the report to be out. But when you're asking the court to strike or to go beyond the deadlines, the three things that always matter is due diligence, surprise, and prejudice. And if you look at our motion, Your Honor, at Exhibit M, that's the affidavit of Wendy Carlson, who shows exactly what she went through on why she couldn't get her expert report out on that date. And it's because she had a debilitating back injury, and defendants couldn't even contact her because she was in the doctor's office for so long. When she finally got back to us, that's when we had these conferences with Mr. Shadhari about this situation. And that's Exhibit N and O of our response. And on Exhibit N, it's Mr. Shadhari, or I should say just the plaintiffs, are asking me to send them a Rule 11 agreement. And I called him up and discussed how Wendy Carlson had this back injury, and they sent us, so we were going to do a motion to strike. And so we agreed that to do this. And if you look at the emails on Exhibit N, Mr. Shadhari is actually getting me multiple times saying, hey, are you going to send me that Rule 11 agreement? Are you going to send me? I believe the terms, so I'm just going to quote him, I believe it will be acceptable based on the terms we discussed yesterday, but of course I need to see the actual agreement. And I said, we'll send it over this afternoon. Apologies for the delay. Attached is the Rule 11 agreement. And then Exhibit O of our motion is the Rule 11 agreement. And it says, plaintiffs agree to extend the date for defendants to provide their expert report until September 18th. And then we had their dates going back. And lastly, they talk about this MSJ that we included it. And I think that's just a red herring, Your Honor, because right now at this hearing, we're willing to push that back to any date that is appropriate by the court to give the other side enough time to do the rebuttal expert. The only reason we included it is because they wouldn't give us any dates for their expert. So we're willing to change it to accommodate this Rule 11 agreement, which they put in, to accommodate the fact that they knew full well that Ms. Carlson had a debilitating back injury, that she couldn't even be contacted with some of the doctors for days and weeks at a time. And we still got the report. They knew all of this. We timely designated her. There's no surprise. There's zero prejudice. And most of the delay that's happened since this process, since today, is because the plaintiffs are refusing to give their expert. They're refusing to deal or even depose our expert. And it's just a contrived effort to get Wendy Carlson. And this is not, notice how the plaintiff's motion is a motion to strike defendant's expert designation of Wendy Carlson, not any report. They're trying to strike the whole expert, even though we timely designated the expert. And they just failed to ask for a deposition. They failed to look at 195.3, and they just entirely are trying to falsely equate an expert report with an expert. There's no blowing through of deadlines. This is just plaintiffs trying to contrive a way to get out of really, really strong evidence that says, this is poorly executed forgeries. We're going to give it, they're going to put my entire reputation behind it and say, I have eliminated PP Na as the author of these. That's what this whole thing is. There's no untimely designation. There's no blowing through of any deadlines. We hadn't agreed, and there's no surprise or prejudice because we had the agreed order.
Let me hear from the other side.
Thank you, Your Honor. I'm going to put on the screen 194.2. That concerns expert testifying disclosure rules. Under 194.2 F3, you have to actually disclose the general substance of your expert's mental impressions and opinions and a brief summary of the basis for them. That was not disclosed on August 7th. That was not disclosed on August 24th. The only time we ever got, that's the only time we ever got Miss Carlson's opinion was on October 2nd, 39 days after the deadline. He's shaking his head no, but that's not true. The expert designation of August 7th did not have any opinion.
Mr. Chaudhry, you're kind of yelling here. Can you share screen the actual designation so I can look at it?
Sure.
Daniel, can you do that? Yeah, perfect.
I think I actually have it in my response, Your Honor, but let me check. And it's also as a part of we supplemented our disclosures, and in our supplemented disclosures, we also added what she was going to be testifying about. And so we've actually done it twice with our disclosures and with our designation. So they were fully aware that she'd be testifying as to the authenticity of these signatures because we repeatedly told them that in both our disclosures and our designations. So what they're saying is just unequivocally false, because we've done this many times.
Can
and
I
let
see
me
a
find
copy
that in the exhibits here that I have. It was, its timely designation is Exhibit F. Under ours, we put it as Exhibit F to show that. I didn't include my supplemental response to disclosures, which also stated that, but that is also supposed to be on the record as well, that we've actually told them about her impressions on multiple times
Daniel,
and timely designated
can
her.
we please have it on the screen?
Yeah, I'm pulling it up.
That's what the judge is telling us to do. Please share it on the screen, please.
I'd like to find the disclosures that we can bring that up. Our supplemental response to disclosures.
The ones that you filed that you said that were timely, I want to see that disclosure.
Okay.
I've got it right here. Give me one.
So somebody share it.
Yes, I'm going to share it right now. This is the October 7th, the August 7th designation. And you'll see here number three, I'm sorry. The general substance of experts' mental impressions. They say Wendy Carlson will opine on her forensic analysis of the handwritten notes that plaintiffs attached to their petitions, which plaintiffs allege contain the signature of P.P. Na. Her analyses, opinions, and conclusions will be in conformity with the Scientific Association of Forensic Examiners and Forensic Expert Witness Association. Wendy Carlson will rely.
Your Honor,
All right,
if you look at ours,
the judge is talking. The judge is talking, so please don't interrupt me again. I'm going to go ahead and deny the motion to strike. So I do have a question. So there's a summary judgment coming up, and Ms. Carlson was, I guess, her report or her affidavit is cited. Has she been deposed yet?
They have not asked for a deposition, but she is available to be deposed.
I mean, this is literally the first day that, I mean, if you're denying the motion, then this is the first day their expert report's actually in the case.
And Your Honor,
we need proper time to prepare a rebuttal report. And then if they want their MSJ heard after that, and after we have time to do expert depositions, that's fine. But November 9th, I mean, that means that literally I've got 2 weeks to prepare a rebuttal report for a report that's only coming.
When is this case set for trial?
February 2021.
I do agree that I think we need to move the summary judgment. I want both sides to be able to take the depositions. He needs an opportunity to file a rebuttal expert. You need an opportunity to take depositions on both sides of these experts. I don't know if you can do that all by February, but we do need to move the summary judgment back, Mr. Rowland. So,
Your Honor, may I say one thing?
Sure.
Like I run this, law firm with Ms. Chowdhury. He works as my senior attorney. I really spend a tremendous resources to make sure all the deadlines are met. Our agreed scheduling order actually had report due date, which was the same day as the destination. I do want attorney fees just because this is their second time asking for a new deadline for this, because otherwise I don't think Mr. Daniel Rowland firm is ever going to really learn the lesson that these deadlines do matter. I understand Judge Hoffman.
And I understand that, but I've denied the motion to strike, so I'm definitely not going to give sanctions if I'm denying the motion to strike. I think he did that timely designate. I think that designation was sufficient, doesn't require an expert report to be filed at that time. And so I'm not going to do that. I do, if you want to talk to me about when it would be a reasonable time to reset his summary judgment, that's kind of where we are in the process. And so let's talk about that.
On that, Your Honor?
So what are, on the issue of resetting the summary judgment, do you have a proposal as to a date?
Yes, well, we need 30 days from today for a rebuttal report. And then I would propose that would get us to the middle of November. And then we would probably need another, I mean, I'm going to just speak a bit, based on availability of everybody and potentially Ms. Carlson's health issues, maybe another 3 weeks to be able to take the both depositions. and then we'd be prepared. Then we could have that summary judgment motion set for a hearing in December or January, subject to the court's convenience.
I'm kind of
December works for us.
What?
I said December works for us, Your Honor. We're willing to do that.
December seems a little bit aggressive to me, but I was thinking maybe.
Your Honor, I do think December is going to be an aggressive schedule considering all the holidays and.
We can do January.
Yeah, we can do January.
Yeah, I think it may have to push it to January if we're gonna allow this.
On January 4th or 11th.
It's up to them, Your Honor.
Let's say 11th, just because the 4th is too close to the
New Year's
holidays.
Yeah. Okay. January 11th. Let's do January 11th at 10:30.
Thank you, Your Honor.
When is it scheduled? When is it scheduled now? Just so I can.
It's scheduled for November 9th hearing.
9th.
Moving it to January 11th at 10:30. So, Rhonda, the November 9th hearing in this case, it needs to be moved to January 11th at 10:30. November 9th to January 11th at 10:30. Okay, she's got it.
Thank you, Your Honor.
Your Honor, do we have 30 days then to prepare a rebuttal report from today?
Mr. Rowland?
That's fine with us, Your Honor.
All right, so I want an order that details the motion, that the motion to strike is denied. Ms. Lee's client has an additional 30 days to file a rebuttal report, and that the summary judgment has been reset to January 11th at 10:30.
All right,
So, Mr.
thank you, Your
Rowland,
Honor.
I want you to prepare an order with that, share it with the opposing counsel, and then get that emailed to me by 5 o'clock today.
Will do, Your Honor.
All right,
Thanks,
thank
Your Honor,
you
for your
guys.
time.
Thank you, Your Honor.
Good luck,
Bye-bye.
guys. Bye-bye.
Bye-bye.
All right. I think we have one more hearing. It's been a busy morning. Mr. Carter, are you there? Ms.
Yeah.
Ballard, Ms. Barnett? All right.
Morning, Your Honor. You said
Good morning,
one more
guys.
hearing like you said one more hearing like you're not excited to see us.
We're excited. I'm excited to see you guys. It's just been, I mean, man, just one thing after another. It's been crazy. We haven't turned the YouTube stream off all day. So, all right, let me go ahead. This is a emergency motion for discovery. Is that right?
Motion for expedited discovery.
Yeah, that's what I meant. I apologize. I misspoke.
Right.
All right, let's go on the record on cause number DC 2012304. Note that we're still on YouTube. Counsel, make your appearances.
Your Honor, good morning. Barry Barnett for the plaintiff, Luminant.
And Leon Carter and Shauna Ballard for the defendant, Alcoa.
And Your Honor,
all right, let's proceed.
May I also mention that Dan Kelly, who's in-house with Luminant, is also appearing, but he's on the phone.
Okay, sounds good. Let's proceed.
Yes, Your Honor. I'd like to give you
Your Honor, this is Cortland Rickman, also here.
I couldn't hear you, sir, and who you're representing.
That's my co-counsel, Cortland Reichman. I didn't realize he was on. Okay. He represents Alcoa.
Okay, he's your co-counsel. I couldn't hear him, so.
Yeah.
Thank you. Mr. Barnett.
Thank you, Your Honor. This case was filed in September. It has to do with a 60-year-old relationship between Luminant, which used to be TXU, which used to be TP&L, the Ready Kilowatt people. And they had a relationship with Alcoa down in Central Texas, just northeast of Austin, at a place called Sandow. That's in Milam County. The county seat is Cameron, and the nearest town is called Rockdale. And there's an industrial site down there that Alcoa built an aluminum smelter on. So they melted the bauxite or the powder or whatever it was, and they turned it into aluminum. And they used TP&L or TXU or Luminant generated electricity to do it by and large. And as you can imagine, there was contractual relationships that existed from the 50s all the way up until today between these two companies, having to do with supplying the electricity for the power, for the smelter. And over time, Your Honor, there have been 5 different units, each of them coal-fired, fired with Texas kind of coal. The only kind of coal we have is lignite, which is it's the lowest grade or a lower grade BTU wise. But there was and still is, a lignite mine called the Three Oaks Mine that's adjacent to this industrial site. There's a conveyor belt that they used to ship the coal, the lignite down over the course of miles from the Three Oaks Mine, and they'd pile it up outside of these power plants, and then they would shove them into the boiler, and they would fire up the boiler and heat the turbine or heat the boiler. The water would get turned into steam, and it would spin the turbines and make the electricity, and then across the way, the smelter would draw on the electricity and make aluminum. This is a relationship that started back in the 50s and persisted for 60 years. In 2009 and 10, the relationship started kind of unraveling. There was a dispute and a big lawsuit that was filed down in Milam County. It went to a jury. The jury found for Luminant against Alcoa's $500 million claims against Luminant for what they said was making them shut the smelter. After that, there were discussions about reducing the footprint of the relationship. And then in 2017, the contracts that we're calling the key contracts, in this case, were entered into between Luminant and Alcoa, recognizing that the smelter was going to be shut for good. So they weren't going to need the electricity, but because they had entered into this long-term power supply contract, they needed to unwind that. So they paid us a bunch of money, $237 million or so, to terminate that agreement. The 2 power plants that were still running have been shut down since then. And now we're trying to exit that property. And we went through a process to find the appropriate company to do the remediation and the decommissioning. It has to be done because, as you can imagine, in this industrial site, there are things that need to be handled over a period of time. And in order to assure that that's done properly and in a timely way and in compliance with all EPA and Texas environmental regulations, you need to make sure that the people that are doing it know what they're doing. As a result of that need, Your Honor, Luminant went through a search and a bid process to find the appropriate company to do it. And the company that ended up working out, submitting the winning bid and is presently ready to sign a contract that would take care of all of these issues is a company called Parrot Development. It's an affiliate of another company called Commercial Liability Partners that does this all the time, all over the place. It's got plenty of financial backing, knows what they're doing. And we're ready, willing, and able, and they are too. There's a declaration in the record that says that, to ink that contract. And that contract will provide for a couple of really important things for purposes of the relief that we're seeking. One is the real estate that Luminant owns in this industrial site, acres and acres, are going to be sold to Parrot Development. So this is a real estate transaction. They will also take responsibility, but secondary responsibility, for complying with remediation and decommissioning obligations that Luminant has, and will take secondary responsibility for complying with and exercising the rights under the contracts, the key contracts I mentioned earlier, between Luminant and Alcoa. There are 4 different key contracts. One of them is a ground lease having to do with the conveyor belt. Another one is called a discharge agreement, which has to do with processing of water. There's a place called, there's a body of water called Lake Alcoa, which is where after the water is processed, it's put into, that's there partly to help with the cooling of the power plants, which of course aren't running anymore. And then there are a couple of other agreements, one called the Plant Services Agreement. The Plant Services Agreement called for Luminant to use services that Alcoa provided to Luminant, primarily back when there were power plants that needed to be run. And that's a very expensive agreement. It has cost us something like $368,000 a month for the privilege of being able to access the services that are available under that agreement. We recently gave the 6 months notice called for by that agreement to terminate, and it will terminate as a result of that notice at the end of February of 2021. So that's a lot of background that gets us to why we're here today, Your Honor. The contract, Your Honor, if you have any questions, I'm happy to clarify.
Okay, yeah, I'm sorry, no, go ahead.
Okay, thank you. We're ready to sign this deal with Parrott Development. The contracts that need to be transferred, licenses that need to be given to Parrott Development so that they can get on doing the work that we're going to still be on the line, will still be contractually responsible for directly with Alcoa. Alcoa is obligated to consent to the licenses and the transfers that need to take place in order for us to consummate this transaction, including the sale of real estate. And they're refusing to do it. And they're refusing to do it because they say, we need to know a bunch of information about Parrott. We're afraid you're going to do something that you can't do under the contracts. So we're going to withhold our consent until you give us a bunch of information. The result of that, Your Honor, is they've just about worn Parrott out. This has been going on for months and months. It's been 5 months that we've been ready to close this deal. There were some other things that Alcoa did, kind of persnickety. There was some clay that they were supposed to give us and they delayed giving us that, and they finally did do it. So they've been dragging their feet for a while. And the relief that we're asking for and that we are seeking expedited discovery regarding is an injunction, a temporary injunction that would prohibit them from interfering with the consummation of this transaction, including the real estate deal. There's a Texas Supreme Court case that gets cited all the time for the standard for getting a temporary injunction. It's called Butnaru versus Ford Motor Company. That case involved Ford's attempt to exercise a contractual right to block a sale of real estate. And the Supreme Court said it was appropriate for the trial court to issue a temporary injunction prohibiting the Ford from exercising this contractual right of first refusal that was preventing the consummation of the real estate transaction. And as the court knows, I've been talking about real estate or real property because that Butnaro case says that when you're dealing with a sale of real estate, that there's irreparable harm because of the uniqueness of each kind of real estate. There's evidence in the record because we submitted a verified petition, and we've also supported it with a declaration of the Senior Vice President of Engineering at Parrott Development that this deal is ready to be signed. And if it's not signed very soon, that Parrott is going to walk away from it, with the consequence that the deal for the selling the real estate will be gone, and there will be significant delay if we can get somebody else to come in and do this work, particularly given that we've got Alcoa refusing to do it. Now we get to what we're actually asking the court to do. What I'm actually asking the court to do is to please require Alcoa's counsel to, and I'm not talking about Mr. Carter, please make them agree on a schedule for getting these 6 document requests and narrow, targeted, specific categories of document requests and topics, deposition topics on the same things. Let's work out a schedule where we can depose the Alcoa person or persons and get the documents. And if they want documents and depositions from us, then fine. We're happy to do that. From the moment Mr. Carter sent me an email, 20 minutes after he sent me an email saying, hey, I just got hired. Looks like there's a motion for expedited discovery. I wrote him back within 20 minutes and said, Leon, that's great. It's wonderful to have a fantastic world-class lawyer on the other side. We're looking for we're working towards a temporary injunction. This is in the reply that we submitted this morning, Your Honor. We're working towards that, and Judge Hoffman has set us for hearing on October the 16th at 11:15. In the unlikely event we can't work out a schedule ourselves. I'm quoting, that's what I wrote him back. And then I asked, when can we set up a time to talk? And then because one thing or another, Mr. Carter, I'm sorry, needed to get his California counsel, Ms. Ballard, who I think is on, and Mr. Reichman, I believe also is with Ms. Ballard in California. I want to say the Bay Area. That was not, they couldn't talk on Friday, so we talked on Monday. I made clear to Mr. Carter and Ms. Ballard that this is a two-way street. If you want discovery, tell me what it is. Let's work out a schedule. Then we agreed to talk again. But again, because they had problems getting together, that got delayed until Wednesday of this week. And I repeated my request that we work out a schedule and that they tell me what they want. But by that time, they had filed an opposition to the motion that said a number of things that just aren't so, Your Honor. And I felt compelled to file a reply today in response to that details those. One of them is that we never served them with the discovery requests. And I looked on the court's online docket, and it includes an affidavit of service. This is on the court's online docket that certifies that on September 12th, we served the citation, plaintiff's original petition, notice, and doc request. That's in the court's records. And we also have submitted to your honor as Exhibit A to the reply, the email that the process server sent us with the actual document request and deposition notice attached to the email they sent us on September the 12th. They also say we don't tell them what discovery we want. And Your Honor, we have 4 topics, and it's even narrower than 6 topics. 2 of them have to do with documents. Tell us about what documents you produce. So it's really just, why are you messing with this deal? And don't you know it's going to destroy our ability to do this work? We want to pin them down on that before we have a temporary injunction hearing. It's not rocket science, and it's not.
So Mr. Barnett, I'm looking at the docket for this case. I don't see that we've set a temporary injunction. Is that set already?
It's not, Your Honor, and we called to see whether we could get a setting, and the word we got appropriately was, well, have you actually filed an application for it? And we said, well, we did in the petition. We've asked for the relief, but we've not submitted affidavits in support of it. And we want to do the discovery first. And so really the first thing we need to do, I think, is, and that's the relief we're asking for, is let's get a hearing set and good lawyers can work out the schedule. So that's, you're absolutely right. The first thing to do, I think, is to get it set.
And Your Honor, this is Leon Carter on behalf of the defendant Alcor. I just want the record to reflect that when Mr. Barnett, who's a good friend of mine, said that I was a world-class lawyer, the court laughed at that. I heard that. I heard that. I want that to be on the record. That I heard that chuckle. That kind of made me feel that big.
I want to point out, I was chuckling because you've gotten so many awards lately that I felt like we were getting yet another award for legal arguments.
I was one of the ones who spoke for him.
He sure did. He sure did. He sure did. He sure did. But Judge, first of all, I want to say that we object to this hearing. This hearing should not be taking place. And you asked an appropriate question a moment ago about, have you filed an application for temporary injunction or temporary restraining order? He did at 10:42 this morning. He filed that. He filed his petition on September 1st. And let me go back. The parties, I'm gonna fill in a little. Yes.
Let me ask a question. Are you saying we shouldn't have this hearing because he hasn't filed a temporary injunction and therefore there's not a need for expedited discovery? Is that what you mean?
I'm saying both. Okay. His motion of expedited discovery he does not plead good cause. He has not met the good cause standard for expedited discovery. And at that time, he had not filed an application. At the time that we filed our response, he had not filed an application. So even now that he has filed an application, we would need more time to respond to that. We haven't had any time. So let me go back a little bit. The parties, I think Mr. Barnett left out a couple of important facts. Again, we object to this hearing today because we don't feel like that we should have had this hearing today. In October 2017, the parties entered into a series of contracts. In October of 2019, last year, a year ago, this month, the parties started discussing the possibility of amending those contracts and even discussed that the third party, the non-party that Mr. Barnett talked about, Parrot, would take on some of the obligations on the contracts. So the parties were talking from October of 2019 to about June or July of 2020, and they couldn't reach an agreement. So what now Illuminate is requesting you to do is alter to status quo to get us to force us to sign some amended agreements, to alter the contract, to have a new contract and force us to sign some amended agreements to put obligations on us that we shouldn't have on us. They are requesting this court, pursuant to an agreement with Parrot, and I want to talk about that in a minute, that Illuminate and Parrot can dump toxic waste and chemical waste in our lake, and that they're not responsible for cleaning it up. They're not responsible for seeing what happens to it once they dump it into our lake. we would be responsible. And when they told us that, we said we will not amend the contracts and take on those terms and conditions because we shouldn't be responsible. And as Mr. Barnett indicated, this is a real estate transaction. In their limited motion for discovery, expedited discovery, they filed on September 18th, they state that they were seeking damages arising from Alcor's delay and refusal in performing contractual obligations and the resulting delays in and endangerment of a pending transaction involving transfer of real property and other rights and obligations to a third party. This is not language that entitles someone to an injunction. And that's why we're saying, and we've had several discussions with Mr. Barnett. He and I are friends. We've known each other a long time. And like he said, we have mutual respect for each other. And I asked him a couple of days ago on the phone call, I said, Mr. Barnett, what are you trying to force our clients to do? I want you all to agree to the amended contracts that we submitted to you guys. And I said, well, we can't do that. There's some obligations in there that you want us to take on that our client is not willing to take on. He said, well, that's what we want. I said, Mr. Barnett, I don't think you can get an injunction for Judge Hoffman to force us to sign a contract that we don't think we are obligated to sign. And I said, also, because this is a breach of an anticipatory contract, your remedy is in damages. Let's say the sale with Parrot doesn't go through. Sue us for everything. You've done it before. Sue us. And whatever the damages are, you'll get them. But we don't think you have a basis to do that. And what we've heard, Your Honor, lately, and my co-counsel can speak on this as well, is that the negotiations with Parrot and Luminate ceased months ago, even before they filed this lawsuit. Parrot ceased negotiating this contract with Luminate and other contracts. That's what we've heard. So the fact that they filed this lawsuit saying that we've interfered with the contract with Parrot, I don't think the evidence is going to bear that out. And so what Mr. Barnett and I and Ms. Ballard have talked about on the phone, Mr. Barnett, when we first talked, and he did call me within 20 minutes, he said, we need to get a deal done with Parrot by the end of the year. That's our timeline. By the end of the year, we need to get a deal done. And I said, Barry, you can't force our clients to agree to an amended proposal or an amended contract that we think doesn't take care of our clients' concerns and issues. You just can't do that, Barry, whether it's the end of the week or the end of the year or the end of the decade. You can't do that. I understand there are some disagreements about that, Mr. Barnett, but you can't force us to do that. So we can continue to talk, and I tell you what, send us documents and let's talk about exactly what you're saying you want from our clients. And we got some documents, but we're still at an impasse. And then, like I said, this morning at 10:42, right before the 11:15 hearing is when we get this application for an injunction that we have not had an opportunity to respond to. So it's our position. And I asked Barry, I said, okay, I'm sorry, Mr. Barnett, I apologize for not being formal. I said, Mr. Barnett, let's say you get some depositions of our clients. What are you going to ask them? Why didn't you sign this contract? What obligations did Luminate and Parrot impose on you that you didn't think you could live with? It doesn't matter, Barry, why we didn't sign it. We didn't sign it, and we didn't have to. And Judge Hoffman and no other judge in this state can force us to sign it. Even if we have a temporary injunction here, what is that going to prove? They didn't sign it. So, Judge, what would you do? Okay, they didn't sign it. Well, Mr. Carter, you got to force your client to have those conditions and terms. No. And so we've told them that. We said we want to, in the spirit of good faith and cooperation, we want to continue to talk. Maybe we can come to an agreement on something because our client wants an agreement. There's no doubt about it. But you're not going to shove it down our throat and have Parrot or any other third party dump chemical waste in our lake on our property and say, deal with it, which is basically what they've done. You deal with it. And so that's why we're saying.
So let's kind of talk about the big picture here, which is, if I'm kind of understanding, there's a lot of stuff there.
Yes.
There is this, that Mr. Barnett's client would like to get this done by the end of the year.
Well before that, Your Honor.
Okay, all right, before the end of the year. we need to set a temporary injunction. It seems like this case might be appropriate for a quick mediation, but I don't know if you know more about the situation than I do, but I feel like it would make sense to do a mediation prior to the temporary injunction. My thought is maybe set the temporary injunction mid-November, maybe.
No.
Give you.
That'd be too soon for us. But I have no problem going to a mediation, and Mr. Reitman and Ms. Ballard can speak to that. I probably have no problem going to a mediation sometime in mid-November. But as far as setting a hearing for that time, that'd be too soon for us.
Someone is trying to talk, but I can't hear them.
I can't either. I don't know who that is.
This is Cortland Reichman for Alcoa, Your Honor. I was just, I thought Mr. Carter was calling on me. I think a mediation would be useful, and we'd be glad to mediate. And I think mid-November sounds, next few weeks sound right for a mediation.
Your Honor, I do have some disagreements with several things that Mr. Carter said.
That's not the first time. Come on. Come on, that won't be the last time either.
Okay, go ahead.
Well, I'll tell a Steve Sussman story before I get to it, if you don't mind. It illustrates what I'm.
Sure.
Uh-oh, I'm gonna feel this one, I'm sure. I don't know if I'm liking this, Mr. Barnett.
Back in the corrugated container case, the judge is a federal judge down in Houston, John Singleton, great judge.
I know, yep.
And the judge was, there were some lawyers that were playing. He had a report from one of the defendants that said that there had been a discussion during a golf game about something having to do with the case, and I think it may have even had something to do with Singleton. But the person that was reporting it's in the nature of tattling on the person who said something on during the golf game. And Judge Singleton patiently listened to it, and he said his reaction was, I think that was a violation of the golf course privilege. When Leon Carter and I were talking, and Ms. Ballard was also on the phone call too, it was a Zoom call. We were talking just like this.
Good.
And the purpose of that call, and I thought this was going to be what it was, we were going to have a confidential discussion, heart-to-heart discussion, to help Mr. Carter and Ms. Ballard get up to speed as soon as possible so that they could understand exactly what the very few issues, at least that I thought, separated us. And as a result of that candid discussion, in which I did assure Mr. Carter that my client's hair is on fire about getting this done, and they're very worried about it falling apart. And I'll come back to that. I sent them the contract, and I sent them a couple of emails with the contract and said, should we get the clients together to work this out? And after I sent the contracts, I didn't get any response. I followed up and said, we're going to talk. He said, we should talk next week. It's already next week, and I haven't heard from you. And they say, no, we can't talk, and we don't think the lawyer should be, the client should be involved. And so finally, I think it was 2 weeks had passed by this time, Your Honor. I'm trying to get them to focus and tell us what they think the issues are. And what we get is this dadgum response that just makes stuff up, including that we didn't serve them with the discovery and that we haven't filed an application for injunction. That's the first thing we did. We filed a petition that expressly asked for a temporary injunction. And the only thing we've done differently is now there's some affidavits behind it and a verification and a declaration behind it. But that's not what you decide a temporary injunction on. We're going to have witnesses to come testify. So nothing's changed. We're asking for the same relief. Mr. Carter said, we want to dump waste in the lake. That's not so. The only thing that is going to happen is that Parrot Development will be able to exercise the rights that Alcoa is already obligated to give us to process water. It's not going to be a whole bunch of different stuff as a result of that. And it's going to be in compliance with the contract. And furthermore, something that I really want to stress, each of these contracts, we are still completely obligated under them. We're just adding Parrot to take care of the things that need to be taken care of. And we're just going to be continuing to exercise the rights that we already have vis-a-vis Alcoa. So nothing's going to be different. And if they're worried about there being a breach of the agreements that we will be operating under, then they should say what it is.
Guys, can I just say this real quick? I feel like we are kind of trying to argue this case. What I'd like to do is just resolve now this issue, which is let's set the mediation. I need to set the temporary injunction. I think we probably do need to have some type of maybe somewhat expedited discovery. So let's focus on that because I am running out of time. And
okay, let me say something for 3 minutes then, Judge, to respond to that. Two things. One, in the plaintiff's, it's the plaintiff's original petition. That's it. Doesn't say an application for injunction. And then on page 9 of their original petition, where it says claim 4 injunctive relief, what they request in paragraph 39 is Luminant request a temporary injunction and permanent injunction barring Alcoa from breaching the plant services agreement, including section 14.10. So they're saying that we are breaching the agreement and they want an injunction to prevent us from breaching it. This is a breach of contract case. And so what I told Mr. Barnett in my privilege that he talked about is that we have the contracts. Send me, and you can, and Mr. Barnett can say this. I said, send me an email telling me exactly what you're saying you want us to do. Didn't I, Mr. Barnett? Did I say that in one of those calls? Send me an email telling us exactly what you want us to do, because in reading your petition, I can't tell, and we can't tell, and our client can't tell. I never got that email. And the only thing that you're requesting is prevent us from breaching the contract. That is not worthy of an injunction, and that's why we object to a motion for expedited discovery. We don't think you need depositions for that. If we do have an injunction hearing, we need it sometime in December, because I am just snowed under this month and next month. And like Mr. Reichman said, we'll go to mediation, and then if we can't get it resolved at mediation, let us call the court and then get on the court's calendar. But let's not do that now, because this hearing shouldn't have taken place when they filed a formal affidavit for temporary injunction at 10:42, 33 minutes before the hearing today.
Your Honor, I agree that that's the point, but my goodness, I'd never told Mr. Carter we wanted to amend any contracts. I said we want them to not to stop withholding their consent, to stop interfering with this agreement, this transaction that we're trying to enter into. I never said that we're going to amend contracts. And really, Mr. Carter, I don't remember you saying, send me an email. I kept saying to you, I cannot believe you guys don't understand what we want. I've been telling you over and over again. That's my perspective. And Your Honor, we've been mediating with these folks for 5 months. This is a delay tactic. It is not, we're happy to do a mediation, but let's do it next week.
No.
Well, Mr. Carter, your busyness is not diminishing the irreparable harm that we're
going to go ahead and get to the chase. So I do want to set this I want to go ahead and set this for temporary injunction. I'm going to give you guys 3 choices, and you each get to veto 1. So I can't just let. So we can do this on November 8th. Sorry, never mind. I'm sorry, November 9th, November 16th, or November 20th.
You have nothing in December, Judge?
I just want to get it done before then. So November 9th, 16th, or 20th. So each side gets to veto 1. So that may mean, Mr. Carter, you might have to have associate cover a hearing or cover this hearing or whatever. So that's the first thing. So each of you gets a veto once. I'll let Mr. Carter do the first veto.
Mr. Reichman, Ms. Ballard? They're going to be coming. They'll be coming.
Mr. Carter, I would say that the veto the November 16th. I have a hearing that day.
Okay.
Well, I vetoed the 20th.
All right, so we're going to do November 9th. We'll do it at 4 o'clock. So Rhonda, go ahead and set this temporary injection for November 9th at 4 o'clock. So then let's go ahead and figure out the mediator. Which mediator do you use? And who can you get into that quickly?
I like Chris Nolan.
Do you think you can get in that quickly with him?
I don't. Yeah, I know him, but I don't know.
Your Honor, I'll be happy with pretty much anybody if it's going to help Alcoa figure out what they're willing to do.
Stop it, Larry. You got what you wanted.
Not yet.
Yes, you have.
I want global peace.
This is unbelievable.
All right, guys.
We'll find a mediator.
It's everyone be nice.
We'll find a mediator.
So what? Who do we want to use? You want to try Chris Noland, or
who else do you use, Judge? Who else do you use?
I mean, I use some of the former judges. Judge Pfeiffer, Judge Ginsburg is very open. Judge Jordan. I mean, I'm flexible. Whoever you guys want to use, and I love Chris Nolan. The experience I've had is that usually he's not that quick.
I'll make him. Do you know Chris, Mr. Barnett? Don't you know Chris? Don't you?
He's the one who wears bow ties.
Yes. Yes.
Yeah. I've got a thing about people who wear bow ties. I think this is my bias, and I'm ashamed of it. I think people who wear bow ties think that they're different, and they want you to know it.
All right, so I don't think that's going to be a basis to not use Chris Nolan. So
he's a great mediator, Your Honor. I'm happy, and seriously, I'm pretty much happy with anybody.
If we can't get him
on the payroll,
if we can't get him, we'll get someone else.
All right, so this will be the deal. Your order to Chris Nolan. If for some reason you can't agree on a mediator, you're going to Carl Ginsburg.
Okay.
So he's like the backup if Chris Nolan's not available and you can't agree on someone else, because I know he'll be available. Yep. So now let's talk quickly about the expedited discovery. What do we want to do with that?
Well, Your Honor, they've had we served the document requests on September the 12th. So Mr. Carter certainly hadn't had them that long, but they've been served that long. I'd like to get a response to them next week, and I don't think there are going to be that many documents, so I'd ask that their response be by next Friday. And if they want to give us a document request, we could get the following Friday. then I think we can do that. And then the following week, well, we could take deposition.
You want to do one deposition?
I think one, Your Honor, I may need to do, unless they'll stipulate that Mr. Clayton's deposition is not necessary and we can just use his declaration. He's the parrot guy. We might need to do a short one of him.
Mr. Carter, what are your thoughts?
Ms. Ballard, Ms. Reichman, the document, I think Ms. Ballard has been taking care of that issue. The deposition, can we limit the deposition to, instead of a 6-hour deposition, a 3 or 4 hour deposition of our person? I mean, this is, I don't know why documents or anything is going to be necessary when this is a breach of contract case, and they just want to know, why don't you agree to the amendments that we want? I mean, I don't understand this, but do we need a 6-hour deposition for that?
I don't think we
I would suggest that each side get a 3-hour deposition. That would be my suggestion. Each side gets a 3-hour deposition of a corporate rep. That's what but if you feel strongly, I can be persuaded otherwise.
Ms. Ballard wanted to say something. Hold on there. Go ahead.
Your Honor, I do think the deposition of a parrot representative is going to be important here. We're trying to figure out, we don't have those field documents, know nothing about them. No due diligence has been provided in response to requests that Alcoa put out in February about the nature of the deal. This has some significant environmental implications that we don't understand because no due diligence has been provided. Some of that information we suspect is exclusively with Parrot. So I think for us, we'd need 2 depositions.
You said 2 depositions?
I mean, the Parrot and Luminant representative.
And we would want documents from Parrot. What if we can't get them under the normal course because of the time frame? You know, they're not a party to the lawsuit. They can drag their feet. So what do we do about that?
I believe they're based out of Puerto Rico.
That's a good question, Mr. Barnett. What about that?
I can find out. There's a lawyer who's not in Puerto Rico, outside lawyer that I've spoken with. I can ask, and of course, it's in my interest to facilitate, so I will.
So who do we submit a document request to then on Parrot and a deposition notice subpoena? Who do we submit that to? To you?
No, but I'm going to try to help you cut through the red tape that otherwise would apply.
Is Parrot here? There's no one here for Parrot, right? I mean, on this call, anyone here for Parrot?
I don't think so.
No.
I mean, November 9th may be kind of ambitious to try to get this done.
That's my point. It was.
But by the same token, December seems too long too.
They wanted it done by the end of the year. He wanted it done by when we talked, and Mr. Barnett can correct me.
We're going to have to get off this by the end of the year thing, Mr. Carter.
Okay, you didn't tell me that?
That's what you told us. That's what Mr. Barnett relayed to us.
Yeah, and you remember the hair on fire comment too?
You weren't talking about my
Hey, guys. Okay.
That's why I keep saying December, though. That's why I keep saying it.
Let me see this.
On the document side, the complication with, like next week on the documents is as we've said, there's environmental implications here. So the documents may be broader than, just exchanging contracts.
Maybe we should do this if everyone can agree. What if we did I'm beginning to see Mr. Carter's point about why I didn't know about the Parrot issue. I didn't think about that. So maybe November 30th instead, just to give you guys kind of as compromise. Would that work for everyone, November 30th at 4?
Can I unveto the 20th?
Or the 20th is fine. Which would you prefer, Mr. Carter, the 20th or the 30th?
Oh, yeah, the 20th for me, because the 30th, because I'm sponsoring the Texas General Counsel's Forum. I got to be there the 19th and 20th. It's by Zoom, but I'm one of the hosts, and I got to introduce people and all that on both those days. So the 30th.
November 30th at 4 o'clock.
Okay.
I'm going to allow the discovery. So just summarize and correct me if I missed anything. We're going to do a 3-hour deposition of Mr. Barnett's client, a 3-hour deposition of Mr. Carter's client, a 3-hour deposition of Parrott, and the written discovery. Is the written discovery just late? Is that the deal, Mr. Barnett, that you've sent it, but they haven't answered it?
No, I think that there's still time for them to do it. The deposition said by X day or when the court orders. The
deposition or the interrogatory? I thought you said written. You said
deposition, and there's also document requests that gave them the 50 days that the rules provide if they haven't answered yet. So the response is due by default.
So there was a subpoena ducis tecum attached to the notice. Is that I thought you said you sent written discovery as well?
Yeah, I did. Well, just those two things: the deposition notice with the 6 topics, and then document requests with 6 categories that correspond to the topics.
As a ducis tecum or as a request for production?
A separate request for production.
Okay. And when is that due?
I believe it's the 29th. That's the 50 days.
Your Honor, we've got a copy of what was served with the complaint or the petition, and it did not include the discovery. We've got it from CT Corp. It was served on September 21, so that's due in the ordinary course on November 10, I believe. The responses.
November 10th is when it's due?
Yeah, that's when the written responses are due under the service.
At this point, other than the 3 depositions, I'm not going to order any expedited discovery unless, Mr. Carter, do you need any expedited discovery?
I don't think so, Your Honor, other than the depositions.
But Mr. Barnett, I will say this: if they don't respond to your request for your, if they don't respond to your written discovery, then obviously move for an emergency motion to compel so that we can get this done.
Let me take that back then. So if he gets a document request, we get a document request. I thought you were saying no document request.
No, I thought he already sent a document request.
He did, but then you said 10 minutes ago that we could agree that we could send him some and he would answer those pretty quick.
Oh, okay, that's fine.
Right, Barnett?
Right.
I'm confused. Their responses are due on October the 29th, not November the 10th.
Whenever they're due, when we send you request for production, you will get us the documents within 7 days of our request, I think is what you said.
Actually, what I said was next week, y'all respond by next Friday, which is 7 days from now.
Okay.
Then you send us the requests that you want, and we'll respond to those by the Friday next.
Okay.
It'll be 14 days from now.
Okay, kind of to summarize all the orders then, and Mr. Barnett, you need to draft an order that details all this. The temporary injunction set for November 30th at 4 o'clock. The case is ordered to mediation with either Chris Nolan. If he's not available before the temporary injunction, then the parties can agree to a mediator. If they can't agree, then it goes to Carl Ginsburg. There's 3 depositions ordered of 3 hours apiece of corporate reps for both sides and a representative of Parrott, and then the Leon Carter. And then what you just agreed to, I didn't quite catch it, but I think he was going to answer discovery next Friday, and then you were going to answer discovery the Friday after. Detail however you want to put that.
Mr. Barnett, go ahead, Judge. I apologize.
And so anyway, so that's the entire order, unless there's something else I missed.
Yeah. We did not agree to have the documents by next Friday because I don't think Miss Ballard, can we have documents by next Friday? We need a couple of weeks at least, don't we?
We need a few weeks to have that. If you're talking about a written response next Friday, that's doable, but to get all the documents by next Friday isn't. And
we can't do that. We can try to do that. We'll do our best to get all the documents, our rolling production by October 30th. And then we will send you a request for production on what? Can we do that one day next week, Ms. Ballard? Send him a request for production, and then you can take 7 to 10 days, Barry, to get us the documents.
And the subpoena for Parrott would include some documents because we don't have any of the agreements with Parrott. And many of the issues involve what Parrot plans to do and the environmental implications of it. So they're sitting in Parrot.
One thing I want to make clear is any discovery requests, any ducus tecums that are attached, whatever, need to be narrowly focused, unless you guys all agree otherwise, on the issues involving the injunction, not just general discovery. All right. Anything else, guys?
I know you're down, Judge, but I'm still trying to get a picture of what would an injunction look like. What can you order us to do? I don't get it.
We'll see. We'll see.
Yeah.
Yeah, read Butnaro, Supreme Court case. I'll send you another copy.
I got it. I read it. Dump our waste at our lake at any time. Okay. Thank you, Judge, for your time.
Your Honor, I'm not sure.
Okay.
I'm right. We're going to get a response to our document request by next Friday. But
no, by the 30th.
And then, but the documents will be produced by the 30th. That's what I thought.
Okay. All right. So documents.
Ms. Ballard,
we'll produce the documents on a rolling basis. We can get a good chunk by Friday. My concern is the environment. Alcoa is a large company, and we've got some environmental issues that are involved here, and so it'll be a rolling basis. But yes, we'll produce documents.
By the 30th. I'm just trying to draft an order
because of the broad implications.
Guys, you guys can work this out, I'm sure. So you guys work out the terms exactly of how that's going to work. But my understanding is that, Mr. Carter, you're going to produce the documents, all the documents you have in your care, custody, control on this issue, or responsive documents by the 30th. And then you were going to send a request for production over there next week. And then he had 10 days, I think, to respond to them whenever you send it. So
the only clarification I would make, you said all the documents. We will get as many documents on the 30th as we can. We could produce documents after that.
All documents you currently have in your care, custody, and control.
That we can get.
The problem, Your Honor, I'm sorry to, what we're talking about based on this request is potentially hundreds of thousands of documents. And so that's why you're hearing our side be cautious about promising. This is not like 10 documents. The requests, while they're few, they're extremely broad, and we can't commit to producing all documents in our possession, custody, control if that's hundreds of thousands of documents within a week or two. We just can't do it.
And we need to file objections to those document requests. We have not.
I'm not overruling any objections. I'm just saying.
Okay.
Yeah. You know, I really will be surprised that any document request I have heard is calling for that many. They must be thinking something very different from what I'm thinking.
Well, to put a
So
pinpoint
Guys, okay. I've done my order. Go ahead and draft it, share it with each other, try to get it to me by Monday. I know it's kind of complicated, but I want to by Monday. I'd like to be able to sign it on Monday. Try to get it to me by noon on Monday if at all possible. All right, guys. Great to see everyone. Always an honor to see you guys. Great lawyers, both sides. I'm looking forward to working with you on this case. If I would have the interns introduce themselves, but I need to get off the call. So
will the hearing be by Zoom or in person?
It will in all likelihood be by Zoom unless there's a strong.
Okay.
My policy is on my website, which is you can request a live hearing, but I'd have to have a phone conference. If there's some reason to do a live hearing, which I can't imagine why there would be, then everything is, the Zoom is the default basically.
Okay. I just didn't know, so I wanted to know. Okay.
That's okay. Great to see you guys. Good to see you. Bye-bye.